This most grievous case puts to the test the fundamental right of each and every individual that they have to a fair trial, no matter what the charge. We have put before the court issues that indicate a clear denial of that right to Mr. Ormsby. Our request to change venue was denied, even though the venue was so tainted that the jury pool was weeded out to a number so small it could not provide the full complement of peremptory challenges set by the rules. When the state forensic psychological examiner testified at court that her office was independent and did not work for the state of prosecution, we were denied the right to examine her boss, the head of state forensics, who had, in fact, spent hours prepping the state police for their interrogation of Mr. Ormsby in this case. We were not permitted to effectively question the defense's psychological expert, Dr. Catherine Thomas. Mr. Ormsby's sentence was enhanced because of his assertion of his right, his constitutional right to a fair trial. Our request for an instruction was denied that would have informed the jury of the substantial protections for the public that Maine law mandates had they returned a verdict of insanity. But overarching all of these issues is that this case is built practically in its entirety upon words wrested from a young man of barely 20 years whom the state's forensic psychologist found to be immature and to be more of an adolescent than an adult with an impaired cause and effect thinking.
The only issue that the state intended to address is the motion to suppress. As Justice Meade correctly pointed out, the motion justice made findings of fact, some of which supported a finding of custody, some of which supported a finding of not custody. The court weighed the evidence, reviewed the same video that you folks reviewed, and reached the conclusion that there was no custody when Mr. Ormsby was interviewed at the police station. There's no legal reason for this court to disturb that essentially factual finding by the court. As we know, it really doesn't amount to much because at the beginning of that interview, he gave Miranda and he knowingly, intelligently, and voluntarily waived. Get to Justice Levy's point in terms of the so-called invocation, where he said, I plead the fifth at this point. As this court and the Supreme Court have repeatedly emphasized, the best police practice is to clarify, are you invoking your rights, which is exactly what Detective Keegan did. And Mr. Ormsby said, in no uncertain terms, for a minute.